Senator Lee.
Thank you, Mr. Chairman. Thanks to all of you for being here today, and thanks for helping us have greater insight into this legislation. Mr. Tolman, I'd like to start with you if I can. You used to be a federal prosecutor. You were an AUSA, and you were later a U.S. attorney. And I'm sure you've prosecuted people under these tough sentencing laws. In fact, I know you have. Why do you believe, in light of all of your experience as a federal prosecutor, that mandatory minimums should be adjusted in the fashion proposed by this legislation?
There's a need for adjustment, not out of a need to change the ceiling. The need for the adjustment does not affect the tools that a prosecutor has. The need for the adjustment is because the Department of Justice, and as a prosecutor, you care about disparities in sentence, and you care about overpunishment, and you care about underpunishment. This bill is the result of years of thoughtful analysis, and it is modest, and it addresses those areas that had the susceptibility of either abuse or over-punishment, but it is in no way a reduction of the tools or a retraction of the ability to deter, to punish, and ultimately with Title II, it significantly increases the ability to rehabilitate. So we've advanced the balls in all areas.
Now, there are those who oppose this bill, and of those who oppose this bill, many insist that they oppose it because the overpunishment concern that those of us who have gotten involved in this effort and who are behind this bill is somehow imagined. That we've somehow imagined or we've severely exaggerated the overpunishment risk. So I'd like to ask you a couple questions about that. Do you think it was overpunishment in the case of Weldon Angelos, who sold marijuana on 3 occasions over a 72-hour period, relatively modest quantities, happened to have a gun on his person at the time, didn't brandish it or discharge it at the time, but did have the gun on his person? Have you met anybody who thinks that's a just sentence?
I think that's the appropriate follow-up question. I've not met anyone that agrees that that punishment fit the crime.
What about the judge?
In fact, even the prosecutor that prosecuted the case initially offered a 15-year sentence, which is ironic since under this bill, that's roughly about the sentence that would have occurred. But instead, because of the stacking provisions, even the judge was in some ways, I know, so affected that felt that he wasn't sure he could continue being a judge if having to face these kind of sentencings. That's a real example. It's not just an outlier. You hear many examples. It can be common depending on the aggression of the office or the aggression of the investigators.
And this judge was not necessarily known as a minimum sentence kind of a guy.
No, law and order.
Not exactly like he was opposed to the law and order movement.
That's correct. An assistant U.S. attorney in the Eastern District of Virginia before.
Right, right. What about, for example, there's a case that came out of the 8th Circuit involving a gentleman who was renting an apartment in a home, and in exchange for rent, he agreed to lay carpet in a living room and in a hallway of that home. While laying this carpet, he was required to remove the carpet that had been there previously, and in the process of doing that, he discovered a single round of ammunition. It was a 22 caliber round. And he didn't take it and discharge it, didn't take it and put it in a gun. He took it and put it in a box somewhere in the home where he lived and just set it aside, apparently forgetting about it. Somehow it was later discovered that he was in possession of this round of ammunition. He was charged with possessing it. He was a convicted felon and consequently was not allowed to possess ammunition. And he was given a minimum mandatory sentence of 15 years in prison for possessing 1 round of 22 caliber ammunition. Do you think that's a just punishment?
I'm not sure there would be a prosecutor that could justify outside the existence of a homicide that resulted in the use of that ammunition, which obviously is not the case. It's a disparate sentence. If this Congress is concerned with the Department of Justice issuing by fiat a mandate to its prosecutors to ignore certain laws, it should be equally concerned that it could issue a request that they be over-aggressive in this same manner. And that's why Congress taking these issues and addressing them in a thoughtful way can prevent those highs and lows, absurd extremes that should concern everyone.
And Mr. Chairman, if I could take just a few more seconds just to complete this thought. There are those who have attacked this legislation by suggesting somehow that those of us who are behind this bill, who have drafted it, who have introduced it, are acting on the part of a desire to somehow dismantle the major overhaul of the criminal justice system that occurred 30 years ago and revert to a bygone era in which criminals went unpunished or significantly underpunished. As a former federal prosecutor, do you think that is in any way, shape, or form a fair characterization? Is that what we're doing with this bill?
I think it's entirely unfair. It would be akin to someone accusing me for the years that I prosecuted cases that, you know, I didn't care about my service. I didn't care about the contribution I made. We're talking about a bill that is being supported by the likes of Chairman Grassley and Senator Cornyn and Senator Lee and Senator Hatch and individuals that I've watched, and Senator Whitehouse, and that were hard on crime, tough, law and order minded government officials. This should say something and should be a wake-up call to people that both sides of the aisle care about this issue and want to make it right. And is there any other area than when liberty is at stake that we should care about making it right?
Well said. Thank you, Mr. Tolman. Thank you, Mr. Chairman.
Thank you, Senator Lee. Brett, nice to